Hey folks, thanks for joining us today. And we're going to talk about the evolution of ad tech and data privacy. This is the rough agenda. So what is ad tech? Trends, litigation enforcement landscape, managing ad technologies with your privacy program, and then Q&A. So what is ad tech? I'm gonna use a joke from that Saturday Night Live Washington's skit, which is nobody knows, right? Um, Next slide, please. But all jokes aside, just a bit of a primer. I know some of you might know, but it's really tools and technologies that streamline, manage, and enable digital advertising. These are tools used by a bunch of folks, ranging from advertisers, publishers, marketers, etc., to help do things like buy, sell, deliver, analyze ads. Common functions of ad technology include things like ad placement, targeting, optimization, measurement, and automation. Anything else that you'd add to the common functions, Lou or Beatrice?
I don't know about adding to the common function. I think one note that I always try to make when I'm asked about ad tech is how wide and diverse the ad tech industry is. It ranges, again, to your point, to things like targeting all the way to automations, measurement. Like there's a very, very broad and varied set of different tools. And that comes with a very diverse set of data and privacy concerns. So I think even though we use ad tech to categorize a lot of different buckets of tools and a lot of different organizations and companies out there, there are very, very different concerns or thought processes that have to go into evaluating each one. They're not all the same. And maybe that's just my vendor point of view as being one of the companies that falls into one of these buckets. When you say ad tech, you covered so much, and many of us are very different. So it's always important to keep in mind that even though we all sort of group together into this category, we do encounter very different challenges, and buyers of this technology encounter very different challenges and very different obligations when they're deploying these technologies.
And I think while everybody on this panel is sort of somewhere in the ad tech ecosystem, I think that what's helpful for the audience to realize is that if you run or advise on a privacy program, you are also kind of part of it by default. If you have a website, if you're using tracking technologies, if you have a marketing function, if you have sales ops functions, like it's very possible that you are somewhere in the ad tech ecosystem as well. And that's why I think that, webinars like this are helpful so that folks kind of understand that, many of the folks in the privacy space slot in somewhere into the kind of totem pole of ad tech,
I
which is
think,
probably
Val, Beatrice, just to build on the points you made, I think these silos look right, and there's some sinewy tissue in many companies that connect these things, and that's the way the industry has grown up. But I think, as as we think about kind of privacy, because that's kind of what we're talking about today, it's important to also recognize that much of the privacy conversation for the past 25 years or so, basically the lifetime of the commercial internet, has really focused on the left-hand side here, on the ad placement, ad targeting piece of this. And so, when we think about privacy in writ large, it typically is those functions that tend to be the ones that are in need of risk assessment, compliance, mitigation, things to think about when you're thinking about how do I approach the consumer with the right message at the right audience, the right time. Like we've always said, that those kinds of things become in play when we're thinking about whether it's self-regulatory or it's legislation, regulation, best practice, whatever it is. They tend to focus in that area, and I'll hit this point probably more often than the audience will want to hear it during the next hour. But I think that there are two big trends in those two buckets that we don't talk about a lot, but should get more play. And the two trends are and from the industry side. So I've told you sort of regulatorily and legislatively, we've sort of focused on those two buckets. But from the industry side, we've also focused on those two buckets in these two trends. One is what I like to call multi-identifier marketing. It is no longer cookies, baby. It is much more than that. And so you really do have to pay attention to that. And then the second big trend, which is continuing to emerge, is the portioning of ad dollars toward connected TVs. So we'll talk about all that more, but I did want to at least set the context that there is this kind of breakdown between those five silos.
Yeah, and I think that brings up sort of the point that I was trying to make, which is because the focus has been so heavily on, especially targeting in the last couple of years, and figuring out, behavioral targeting, cross-context behavioral targeting, and all these different topics. Having a broader understanding of the different areas of ad tech is really important, because if you try to vet, for example, a vendor based on concepts that are typical of a behavioral targeting vendor, but what they really do is automation, they're not going to give you the answers that you want or you're expecting, but you're also not necessarily asking the right questions. So I think having a more in-depth and more differentiated understanding of how complex the ecosystem is really important to make sure that you are completing the due diligence and you are confident in the vendors and services that you're using, but you're also asking the right questions. Because if you don't ask the right questions, it's going to be very difficult to get the right answers.
Thanks, Beatrice. Let's move to the next slides, I think, so we can dive deep into some of these. So we previewed some of this, and you'll hear some stuff that's kind of threaded throughout. But who are the players, right? Advertisers, publishers, and consumers are some of the common players in this space, and the sort of interplay between them is how ad tech effectively works. So let's actually move to the next slide, Marie.
Val, if you don't mind on that one. I would offer, that it's an extension of the prior slide. Yeah. And in some ways, we think about technology evolving, we think about legislation, regulation evolving, and so on. But at the end of the day, if you think about the consumer here on this slide, the need to stay on the right side of the consumer has not changed and will not change. So I am old enough to say this. I used to work at the Direct Marketing Association in the late 1990s. So this is just before the commercial internet. And there were consumers who were concerned about privacy issues having to do with direct mail. And even before that, if you think about 1960s, 50s, 40s, going back to the 1920s, all the way back to kind of Sears and Roebuck kind of days. And so I offer that historical perspective because I don't think that the privacy concerns of consumers, staying on the right side of the consumer, was born of the internet, nor will it die because we put something on the internet that can change that. I think as technology evolves, that concern will continue to be there. So as we talk about things like connected TV or other media that are coming into play, we will need to continue to consider things like, why did I get this ad and what can I do about it, irrespective of what we do as an industry to comply with regulations and laws that may be coming into effect. So always keep that consumer mindset in topmost, because that will actually be your North Star in terms of being able to be responsive to them about privacy concerns.
Awesome. And we have a great question, but I want to pause on that one until we get to the governance section. I'm just going to remind everybody about it so that we have it at top of mind when we get there, which is around due diligence for publishers. But I want to get through this first component since, I'm keeping track of time here. So real quick, can we go to the next slide? So kind of, the play of what Lou just said is that this is somewhat focused on what happens on the internet. But, that's sort of in vogue right now. It's what we're thinking about right now with respect to ad tech. And this is sort of the interplay between advertisers and publishers and end users and how they work together, right? There's advertisers using demand-side platforms, publishers using supply-side platforms, real-time bidding, ads being delivered, and then performance being tracked. And throughout this, you, the end user, may be seeing the ad. But let's keep going a little bit here. Some benefits of the technology are obviously things like precision, efficiency, scale, and performance. Why does AdTech exist? In some ways it exists, and I'm curious to hear from the other folks here about this as well. But in some ways it exists because otherwise you would just be running ads scattershot, which is what used to sort of happen with TV, right? At some point they just ran ads for everybody. But with the advent of targeted advertising on the internet, you could have Scott might see different ads than I see, right? Beatrice sees different ads than Lou sees on the internet. And these companies want to manage their spend, and they also want to know what is more efficient, what is more effective, who responds better to what type of ads. And all of these are reasons, among others, that people would want to invest in ad technologies to control their ads, to control their spend, etc. Anything else that the panel might want to add on sort of some of the benefits here?
Well, I think for sure, efficiency is part of it, Val. But so is consumer receptivity to some of these tailored ads. We've seen studies routinely show that consumers respond, I forget the numbers, but 2x, 3x times as much to a targeted ad versus something that's either contextual or not targeted. And so, for a company that is looking to either, if you're in the small market, breaking through, or if you are a large company trying to either market a new product or introduce yourself or stay top of mind or whatever, having access to that kind of relevance that comes from responsible targeting is something that was around before the internet, is around today, will be around tomorrow, because it does connect with the consumer. It reduces the frustration of the consumer because it can be a product or service that the consumer is interested in, and that relevance brings it to light.
It's a really good
Yeah,
point.
Val, I guess my 2 cents on this piece on benefits, I mean, I think you capture it here, but I think it really also depends on where you sit. If you're a consumer, I think Lou just kind of walked you through that, right? So the days where we have less time to do more things in our lives, and we're walking around with little gadgets that allow us to do the things that, we used to require us to, say, go to the grocery store or go to the mall. The idea that efficiency can be built for me as the consumer has remarkable benefits. Then there are other uses for ad tech too, not just delivering, say, that new pair of sneakers you wanted to buy, but we see other industries like healthcare using ad tech technologies to identify, say, potential consumers of their services being in clinical care. It has remarkable value in even life-saving efforts. So ad tech is reaching beyond just being able to deliver a pair of sneakers into your inbox or into your newspaper that you choose. So the benefits really are, I think, right now immeasurable, and they will continue to be so long as consumers are willing to make their information voluntarily accessible.
There's also a compliance aspect to it in some scenarios. We always think about compliance when it comes to ad tech as complying with privacy laws, which obviously is relevant, but there are products and services out there that cannot be marketed in certain areas. If you're running a lottery promotion or another promotion as an organization, you might not be able to run that in Nevada, but you might be able to run it in New Mexico. And how do you do that effectively? And ad tech does play a role in that as well.
That's a great point. So looking at the time, I'm going to power through a few slides because I think that we have some beefy topics. And the problem with that tech as a topic is that we could be here all day for a couple weeks and we still wouldn't scratch the surface. But some obvious challenges that do exist are, of course, with the advent of the internet and targeting, and even some of those things that Beatrice just mentioned, like the ability to provide certain ads in certain geos. those all require some level of use of personal data, right? How do you know that somebody's in New Mexico versus Florida versus Massachusetts? You know, IP addresses, right, as an example. How do you know that somebody might be interested in a certain shampoo because they visit a certain website, right? All of those things kind of require data to be driven in some capacity. And some of that is personal, which means that you now are at the intersection of these privacy laws like e-privacy, which is, you know, several decades old at this point from Europe, or GDPR, or California CCPA, or others, right? Beyond that, there are other things like ad fraud, complexity around ecosystems because of these different players, ad blocking technology that sometimes limits your ability to create that specificity that Beatrice mentioned. So lots of variety there, but let's keep going. So tracking is a common thing that is used for ads, right? So I did want to talk a little bit about some examples of how trackers power ads and what trackers are used. And I'm going to talk about them quickly because like I said, we have some beefy topics right after this. But these are some common examples, right? Behavioral targeting, retargeting, personalization, frequency caps, segmentation, cross-device tracking. These are things that, you know, if you're a privacy practitioner, you could maybe have some alarms going off, but I think as Scott talked about a little bit, when they're used correctly, these things are meant to enrich your day-to-day and make it so that you're going on, when you're going on Instagram, you know, if I like watches or espresso, I like those things, right? Like I want to see those ads. I don't want to see ads for something I don't care about, right? And I think that can apply to a lot of folks here, right? You want things to be relevant and useful for you, and companies want to make sure they're controlling what's relevant and useful for you from a spend and other from other measures. Next slide, please. So these are some examples of common ad tracking methods. I want to stop for a second on cookies. Everybody knows about cookies at this point, or many people do. Cookies is really like one part of the equation right now. And we're going to talk a little bit more about cookies and what's happening in the space in the next portion of our presentation. But you know, they're important and they're used for a lot of things, right? Actually, a lot of these things are used for a lot of things. Cookies and pixels and other things may be used for ad delivery and tracking and efficiency, but cookies are also used for things like fraud detection, remembering what language you chose, making sure websites run correctly, etc. And so while some of these are particularly used for ads or for tracking around advertising, like Apple's ATT framework, a number of these other things could have a variety of use cases above and beyond, or regardless of whether or not you have an you know, ad or marketing program. And some of these do place a data packet, as they call it, on your computer, and others don't. That's also a nuance that, you know, may trigger other laws in Canada and in the EU, etc., depending on if something is quote unquote installed on your computer like a cookie, or it's not, and it's simply by virtue of you know, your ad traffic or your web traffic rather.
Val, I would also offer that to your point about, you know, sort of a lot of people know about cookies and think about cookies, and, you know, there used to be a day when, you know, if you did a data inventory, you probably started at what cookies is my website asking for, and that would be probably a 80% of your effort. Maybe it was 90+% of your effort to understand that. But I think in a world where cookie deprecation has been threatened, marketers have increasingly adopted multi-identifier marketing as a way forward, as a way to hedge those bets. And so you can't just look at your cookie call sheet and say, "Oh, this is what I have to deal with." You also have to look at, and you have on here, mobile ad IDs. You also have to think about things like hashed emails, hashed phone numbers, so token IDs. You have to think about, am I doing stuff? And you list here fingerprinting, so probabilistic IDs, you know, and other things like that maybe weren't part of the lexicon or even the conversation a scant 4 or 5 years ago. But today they are a reality, and do in fact also move us from thinking about this as just kind of what does my website do to, and you have it on there, cross-device tracking, where, you know, if you have a token, that token can be good on your website. It can be good on your mobile marketing efforts. It can be used on your CTV efforts, et cetera, et cetera. And so it's important to think about this much more holistically today than even it was just a scant period of time ago.
Awesome. Thanks, Lou.
Yeah.
We're getting a flurry of really, really good questions that will probably need to be addressed during the governance section. So I wanna kind of move through. Lou, I think you and I should just power through the next 2 or so slides. So just real quick, I think this is just helpful in terms of understanding how a vendor like TrustArc may work with your own ad ecosystem. And I have an image here of a moat. The way that I think about cookie consent as an example is sort of that a vendor like TrustArc or even one of our competitors is kind of the door to a moat and a castle, but ultimately your website is that castle and your tag management system is typically the chains that control the opening and closing of a gate, right? And so in other words, like even if you have a third-party vendor like a TrustArc who will provide transparency, who will give people choices and options, you need to have a tag manager through your own website and your own marketing function that not only is aware of what cookies, tags, trackers, and pixels, et cetera, work and what you're using, but are actually controlled by that tag manager. And then that needs to interface with our technology. We'll talk about this a little bit more, but I just wanted to provide one example of, how ad tech might actually impact everybody in this call, right? We all either are at companies where we operate cookie banners, or you've seen them. Maybe you love them, maybe you hate them, but that's just one consideration there. Next slide, please. Lou, I don't know if you just want to briefly touch upon this because I do want to move to the legal.
Yeah, sure. It'll be quick. Across the top, there are the identifiers that are commonly used in the market. DAA makes choices available across all of those, and we do that on purpose because marketers have adopted all those. In the columns, you'll see that there are varying, where does it apply, where does the choice apply, and what is the tool that the consumer uses. Happy to walk anybody through this, but to do it in the middle of this webinar when we have a lot of questions, I don't think makes sense. At the end of the day, just give us a call, give TrustArc a call, and we'll walk you through this. But at the end of the day, it's really about why did I get this ad and what can I do about it? It's just how it is determined by a chart like this.
Awesome. All right. Marie, can you move to the next slide, please? So legal and industry trends. I think the 3 primary trends that this group will touch upon, because again, I'm trying to keep track of time and make sure that we have time to answer these great questions coming in. But the few that I think we've seen that I'd love for this panel to kind of touch upon for a few minutes is cookies, right? It's undeniable that there's sort of this Ross and Rachel from Friends, will they, won't they, with cookie deprecation. I think the first thing to know there is while Chrome has been talking for some time, which is Google's web browser, about not supporting third-party cookies by default when somebody uses their browser. There are other providers like Safari and others who have already by default blocked third-party cookies. I think the thing to remember there is, for one, there's such thing as first-party cookies, which are used for a variety of things, which may include ad technologies. And 2, cookies are really one small part of the equation that tools like TrustArc's control and that are fueling the ad ecosystem at large, right? Pixels, e-tags, et cetera, are all part of that. But Scott, Beatrice, Lou, any other thoughts on the cookie deprecation? I think that there's been personally a philosophical shift away from them, where people are still using them, but people have started to look at these alternatives that are either privacy preserving or simply just to hedge their bets as there's been conversation about it.
Yeah, from our perspective, we see a lot of hedging of bets, and that's appropriate. The market still wants to get that efficiency that Beatrice and Scott and you talked about, still wants to be able to deliver the right ads to the right audience at the right time to serve their consumers. Frankly, I think Scott was talking about other uses for ad tech. We interface with an organization that actually uses ad tech to do missing children and wildfire alerts. There's a lot of great uses for the technology. So just talking about cookies is probably not enough. And that should be a lot of people's takeaway today.
Yeah, I mean, my comment on cookies is, it's a 4-letter word in some conversations, and a lot of data collection technologies are falling in. Pixels might be the next one. That's a 4-letter word. We'll talk about the litigation and regulatory trends that we're seeing in a minute. But you also have to remember that some of these technologies allow us to actually use the internet in the ways we do today. And I'm not defending here the companies that have built massive fortunes off of these technologies. Good for them, right? But if you're running a hospital and you want your prospective patient to find the right doctor, you do need cookies to make sure they get directed to the right landing page so that they can find the right doctor. You can make arguments that's a social injustice thing, right? So someone doesn't need all of the connections in the world to find the world's best cardiologist for their child. So I think we probably need to go back to the early days where cookies aren't necessarily a 4-letter word. They do present a lot of risk, and organizations need to understand, what they're used for at their organization and how they're used. But that's my thoughts on cookie deprivation. There's this other kind of thing hanging out there about the competitiveness of those companies who build ad tech versus those companies that build hardware, and the competition between them. And cookies are probably right in the middle of that.
Yeah, and one thing that I was going to say that kind of ties us back to what Scott was saying originally, there's definitely bad actors in the industry. There always have been. There are in every industry. But the internet has evolved also in a direction that consumers like and want. There's always a supply and demand sort of factor behind the way things work in the world. So sometimes I think when we were in the height of the no cookies anywhere, cookies are bad in all capacities, it was interesting to sort of and it kind of ties us back to the lack of education piece, but it was interesting to sort of realize how people sometimes don't know what the internet without some of this technology would look like. I'm not sure they would like it. Cookies, if I remember correctly, the very first one was designed so that your cart would remember what you wanted to buy. And if your cart on the website can't remember what you wanted to buy, how are you going to buy things? So sometimes I think we become so entrenched in the concept of trying to protect against a negative outcome that we forget how important the positive ones are.
And you see this this is sort of an absurd example, but I remember one time I got an email, being invited to go buy some car, ultra luxury car. And I was like, who do they think they're emailing about this? I was like, I think that somebody got their wires crossed about the buyer here. And I think that that's sort of the flip side. Even when it's not creepy or anything, if you get something that's just not for you, you're like, why am I getting this? Their ad tech must be off. And I think that that's sort of the key here, is realizing that there is that balance and trade-off.
Or you would have never found that restaurant that you really liked in this area that you were visiting. And, is that the way you want the internet to work? I'm not suggesting that we got to take all the bad with the good, but at the same time, it seems like sometimes we're arguing to throw out the baby with the bathwater, and that might not be the way either.
So while I've been trying to punt some of the questions until the governance section, this one's specifically for Scott, so maybe this will be helpful to raise on the fly. It says, is Scott saying that a website wouldn't be able to help someone find a doctor without ad tech? That doesn't sound like a factually correct statement.
Yeah, so and if that person wants to reach out to me, happy to explain my point. But if you look at a hospital's website, right, and we'll talk about this in a second with respect to litigation and regulatory trends, we have the federal government trying to regulate through privacy means how those websites work, right? And so they're using a law that was passed decades ago before these technologies were available. They don't accommodate these technologies to regulate the collection of information. Ensure, the Department of Health and Human Services, through one of their divisions, has said, find a doctor page on a hospital's website could be collecting HIPAA protected information, and therefore it's regulated. My point is, in order to actually find that doctor, yes, you do need some ad tech technologies. So you would need to understand geolocation. If I live in New York City, I don't want a doctor served up in San Francisco. That's AdTech delivering that, right? So you're either providing the information into the website, or the website's going to geolocate you to understand you're looking for a doctor in New York City. And that's my point. So their AdTech technologies, including functional cookies, are necessary for that web page to actually operate with its intended consequences. For those who live in, posh neighborhoods, no big deal, right? You might have a neighbor who can find you the world's best cardiologist for your kid. For those who don't have availability of that website's going to help you find the world's best cardiologist for your kid. And what I'm arguing is AdTech technologies help you do that. That's just one benefit of AdTech. They're like, I agree with Beatrice. There are other negatives to it, so we need to be aware of that as consumers.
So that's actually a really good segue. I mean, look, I think two things. I think Scott is right, and I think that like if you don't want to oversimplify, my suspicion is that there's a possibility that like if you have a local doctor network that's just based in your geography, that it's just a list of phone numbers, and that can be avoided. But I think if you're talking about a sophisticated multi-state hospital system, multi-state connector type program, I think Scott's points apply, which is that you don't want to see a doctor in New Mexico if you're in Maine, right? And I think that some of those technologies to help parse through that stuff and make it easier include technologies that maybe AdTech fueled. But another point that I want to touch on this trends piece before we shift gears a little bit, and I know we're moving quickly, and I apologize, this is a huge topic, right? Is healthcare data in general, right? And that was great tee up from the person in the audience and Scott here, which is Washington My Health My Data was a big deal this year. Additional laws like the New York Health Information Privacy Act, and I believe Maryland and others have kind of followed suit. For those of you who aren't familiar, some of those laws, and Scott and team, please keep me honest here, but some of those laws were in direct response to the Supreme Court decision around Dobbs. Some of those laws were in response to the consideration that HIPAA itself, has some areas where they don't directly address tracking technologies in the same way. And so some states have augmented basically HIPAA, in response to Dobbs, so that certain covered healthcare data that isn't PHI under HIPAA may still be considered protected data under Washington My Health My Data or this New York Act and others. And what it's meant in the ad space is that if you're using, and you can kind of see some signals of this beginning even back with Sephora, right, under CCPA, although that wasn't about healthcare data per se. There was, I personally think that some of the reason why the Sephora case gained some prominence is because of the types of data that they were collecting. Because ultimately, if somebody's buying a gender-specific moisturizer for age control, as an example, you can glean some characteristics of that person. And you could see how that sort of dialogue is expanded into these other states and other regions, coupled with some of these other laws. So some of these laws have additional consent requirements. We could spend a whole hour on Washington My Health My Data and others. So we won't do that here, just given the other questions and items to talk about. But that's one big one. The other big one that I think is a trend before we shift to litigation with Scott is children's data. There's been quite a few child-specific acts, ranging from the Colorado's amendments to the Colorado Privacy Act, Virginia's amendments to the Consumer Data Protection Act, the Maryland Age-Appropriate Design Code, California's Protecting Our Kids in Social Media Addiction Act. Brazil had a Children's Rights in Digital Environments law passed. Australia had a Children's Online Privacy Bill passed. And each of these have some considerations. So if you think that you might be targeting minors or children, much like with healthcare, you're kind of in, and we'll talk about a little governance, you're kind of into this like beyond your standard opt-in, opt-out, e-privacy, other type rules. You might have these additional verticals you need to consider when applying rules against. But like I said, keeping track of time and given that these are all big topics, Scott, do you want to talk a little bit about litigation and enforcement trends?
Yeah, so let me just pick right up on that. So the FTC has a health breach notification rule. So where HIPAA kind of falls off because you have to meet two primary criteria to have HIPAA data, the FTC can pick it up. So it's more or less health data, and they take an expansive view of what health data is. It's an interesting study over the last 24 months. So they've been using Section 5 of the FTC Act to bring enforcement actions against websites or web applications. with respect to the collection, use, and sharing or disbursement of particular data. So there's a number that have gotten a lot of attention on the internet. For example, one website could be used to track you and whether or not you're going in and out of certain healthcare clinics. Subsequent to those enforcement actions, which a lot of us kind of scratched our head at, thinking, well, I'm not sure this is exactly what these laws or regulations have been intended to regulate. The FTC went through a rulemaking process, in effect looking to expand the scope of their regulatory authority to cover what I would argue would be the enforcement actions that they just resolved. So they enforce and then through rulemaking expand. Depending on where you sit in the world on whether you think regulation is good or bad, it does make you wonder, are we in a world where, because the legislative process is somewhat broken both in states and in Congress, are regulators looking or having to interpret their own scope of enforcement capabilities to apply to these new technologies, including AdTech, but also to apply to uses of data through AdTech technologies? And the FTC's little case study there over the last 24 months would say at least one regulator, a very important and powerful one in Washington under the current administration, we'll see what they look like under the next administration, has followed suit. But right now, working into the next administration, we're all kind of leaning and wondering what's gonna happen with respect to this rulemaking and what's gonna happen with respect to that particular agency's authorization in this space. I think we're gonna see that repeatedly, whether it's a Republican or Democratic administration in your state or in Washington. On the litigation side, what we're seeing is
Next slide, Marie. Thanks.
Yeah, sorry. On the litigation side, just quickly, why do we attend to all of these things? Well, we attend to some of them because they present a lot of risk, and whether or not your organization is going to be in the crosshairs of plaintiff's counsel or a consumer who doesn't like what you're doing on other things and is going to use this as a lawsuit, we have seen a massive upswell in the last 3 years of all kinds of privacy-inspired litigation. So Illinois' biometric law, which has kind of, I think, probably still leads the day in some of these litigations. On any given day, there's often about 200 plus lawsuits pending in Illinois under their BIPA. This is the collection and use of biometric data. Compliance with BIPA is actually relatively straightforward if you read it, but it's complicated by how businesses use biometric data. If we take those lessons and apply them to other things like wiretapping lawsuits in California, Florida, and Massachusetts and Pennsylvania, where plaintiffs' lawyers are taking laws that really originated out of the 70s and then the 80s. These are the same laws that we talk about in the show Law and Order. Same wiretapping statutes, often criminally focused. And they're applying those to website technologies like AdTech to say, well, you didn't adequately record or collect my information in violation of the state wiretapping statute or the federal wiretapping statute. And we'll talk in a little bit about things like consent and what I call the get out of jail free card of consent. But plaintiffs' counsel and litigants have been very thoughtful in navigating old laws, applying them to new technologies. We've seen this repeatedly, and wiretapping is just one example. And then the final point, something that happened in New Jersey, there was a privacy statute that came on. It was a sad story. Federal judges was targeted for assassination by criminals, opened the door, and they shot the wrong person. They shot the judge's son. It's called Daniel's Law. Daniel's Law was amended in the last couple of years with some kind of cavalier and thoughtful folks who wanted to expand the scope of it. It's now being used to bring over 100 lawsuits with respect to the collection of private information related to law enforcement officers or correction officers in alleged violation of the statute. Interesting there is you have folks who allegedly invested a lot of time and energy in developing a law that could be used for lawsuits. And so we're seeing folks take positions on the privacy side of the plaintiff's bar to pursue kind of new theories with respect to the collection and use of technology through websites. So kind of a cascading and increasing level of risk, Val, that we see. And I don't think that that's going to change regardless of the administration or politics in your state or in Washington.
Yeah, I think the wiretapping stuff is sort of fascinating because of that cross section, right? The Nixon era wiretapping laws being conflated with, modern tracking technologies and not at odds with, but sort of butting up against things like CCPA and other laws. And I think that's exactly where plaintiffs bars and others are sort of capitalizing, is how are courts going to decide. And courts have been split, right, Scott? I mean, that's sort of what we've seen so far, is that courts have been split on wiretapping decisions and settlements.
Yeah, what we've seen both in state and federal courts is the details matter, and the details also will incentivize or disincentivize the folks who are pursuing these lawsuits. So, for those organizations who aren't paying attention or are trying to completely kind of dissolve themselves of responsibility for data collection through AdTech, they're having more problems than those organizations that kind of, have the warning signs up and have done all of their diligence on what they're doing. They're having a much better day in court, in our view.
Okay, cool. Well, I think with the time we have remaining, let's shift gears, since I think that's where the flurry of questions have been, is around governance. Awesome. So next slide, please, Marie. Next slide again, sorry. So real quick, and we will get into these. I'm actually just going to briefly touch on these, and then I do want to start going through the questions, and maybe we'll just roundtable it as a group. Remember, and in the kind of immortal words of our VP of Knowledge, Joanne Furch, it's another technology in some ways for a privacy program, AdTech. And so a lot of the things that you would be doing otherwise apply, right? What technology or vendors are you using, right? It's not just important to know that it's Acme Corp, but it's important to know what tool, right? Amazon Web Services, does one thing. Amazon EC2 does another thing, as an example, right? Google's Cloud does one thing. Google Analytics does another thing. So it's important to understand kind of what vendors you're using, as well as the technologies under those vendors. Of course, learning what personal data is being collected, because that's totally contextualizing. Analyze how it's being processed. Disclosure, right? Privacy notices are one of the first things a lot of privacy pros think about. What disclosure and transparency measures do you need? Do you need a cookie banner that shows what kinds of trackers you might be proposing to use? Do you need ads transparency tools that the DAA supports and TrustArc? Do you need as well as DoubleVerify? Do you need to manage these vendors, agreements, et cetera? Do you need certain contracts in place? What kinds of consent and data subject rights are being required based on what you're doing? Easy example there would be if you're in California and you're using information for purposes of advertising or marketing, you have to consider whether that's considered a sale or a share under CCPA, right? Which touches a little bit on the managed component, because one way to mitigate that would be a service provider contract, like a DPA. Another way would be through things like having a do not sell flow if you are sharing data. Other things include documentation, mapping your data, risk mitigations and considerations are really important. For example, if you're collecting a hashed IP address, that's going to be totally different than if you're collecting somebody's, I'm going to be a little silly, but full biometrics, the retina scan, their social security number, their credit card, et cetera. Those are all going to factor in way into how programs might be managed. So that's just a high level, but I unless anybody has anything to add on the high level, I want to get into some of these specific questions.
I just want to one nuance here. I think it's very easy to think about AdTech, especially here in the US or North America generally, as being kind of an opt-out model. That is not really where the industry is. For more than a decade, the standard has been much more tailored, depending on the perceived or understood risk of particular use cases. And so while an opt-out standard might be appropriate for many of the things that AdTech is doing, don't forget that we do have a consent standard for things that trigger much more privacy concerns. So precise location data does get that treatment. The Val brought up, getting a social security number. Financial account information has that consent requirement built to it. So do other things that could trigger adverse terms inside things like health insurance, credit, et cetera. So please be mindful that even though we're sort of generalizing and summarizing here about opt-in, opt-out, there is kind of this progression of consents that run the gamut depending on where you are in the ecosystem.
That's great, Lou. So I'm going to pick on Beatrice here because I think this might be a good question for you. One of the questions here is, what do you think are the most important questions a publisher should ask an ad tech partner doing due diligence?
I remember to unmute myself. You're proud of me. So my biggest recommendation, and again, like I come from the vendor side, but I'm very, very committed to provide information to my clients, and we work with publishers. So we get questionnaires from publishers all the time. My biggest wish for questionnaires would be that they not be quite as standardized across ad tech publishers. And I realize that that's a lift on the publisher side. However, we very often get we very often get questions that are not really relevant to us, but asked in a way that often it's only a yes or no response, and we can't really provide any context. It just makes the process of providing information harder than it needs to be. So my recommendations are usually to try and develop some degree of conditional logic in your questionnaires, or at least some differentiation based on how or the kind of spend category, the kind of product or service that you're trying to buy. That's how we do our own due diligence with vendors. We have a mature onboarding process, and one of the first questions that we ask in that process is, what are you selling? Because if you're selling non-technology consulting services, you may very well get access to personal data, and we may very well need to vet how you do that. But the questions that I'm going to need to ask you as a consultant are not the same that I would ask a SaaS provider. So having a little bit of clarity in that process and distinguishing and being able to sort of carve out sections of questionnaires that are really not relevant to you. For example, if you do not engage in profiling at all, spending a substantive amount of time answering not applicable, not applicable, not applicable, 2 questions that are not relevant to you may not really be effective use of anyone's time. But also often those questions come with only a yes or no answer. So I've dealt with questions that essentially say, when you collect personal data, do you, for profiling purposes, do you get consent? Yes or no? And I don't have a good way to answer that question because I don't collect data for profiling purposes. But if I say no, it seems like what I'm saying is that I don't get consent, which is not what I'm trying to say. So I think going into the details in those questions and making the questions relevant, or at least categorize them by buckets. We offered, 5 potential buckets of ad tech already, would make the documentation that you have on your end a lot more higher quality, and it will be more relevant. I think just a lot of the time listening to what the vendor is trying to say is really important. And I know it probably comes, you're probably questioning it because I'm one of the vendors, but it happens to me with my own vendors. All of us in the world are buyers and sellers. We're not just one or the other. And I see it with my own vendors. Oftentimes just asking the right question will quell a lot of concern, while, the wrong question might raise concerns or trigger anxieties that are not even entirely relevant.
Awesome. Thanks, Beatrice. I'm gonna try to briefly address DSARs because that's a good question, and then I want to leave a few minutes for maybe Scott and I, but with Scott leading, to talk about mitigations for SIPAs, and somebody asked about that. On DSARs, I mean, look, data subject access requests, for those of you not familiar, it's a term that kind of originates from Europe, but the premise is more relevant. Essentially, data subject access requests stem from this concept of People have the right to be forgotten. They have the right to be requesting an export or a portable copy of their data. They have the right to ask businesses for things like, what data do you have about me and why, et cetera. And my high level answer for AdTech and broadly is data subject and consent rights are critical. And it's not really about should you be doing them. Some laws require them, some suggest it, and in some it's probably just the ethical thing to do. So I think in general it's something to strongly consider. The question to be asking is sort of how do you facilitate some of those things? How do you facilitate those things? How do you facilitate choice? And that's really going to depend on the technology you're using to collect the data to begin with. Because, for example, if you're a SaaS vendor and you're collecting data within your software environment, what a DSAR looks like could be totally different than if you're a medical device provider without software. And so I think thinking about DSARs from an AdTech perspective is similar, which is it kind of depends on what is being stored or hosted, et cetera. For example, a cookie actually is placed on your machine and transmits information versus what a company might have. And so I think a data subject strategy and consent strategy are going to depend largely on what technologies you're using, and that'll dictate what kinds of platforms you might use. For example, if you're only using tracking, a cookie consent tool might make more sense versus if you have a whole collection process, you might need a data subject portal or some kind of email alias where your privacy team manually looks at what they have and how to fulfill them, et cetera. But like I said, we only have 3 minutes remaining, so I do want to at least touch upon SIPA because I think that that's something that comes up often and is consistent with another question somebody had. So I'm going to ask them both, and then I'm going to say 1 second, and then Scott, I'd like you to answer it. Can you talk about how to stay in compliance with the uprise of SIPA requests when using ad tracking? And then similarly, somebody else asked, how do tracking pixels not violate privacy? So Marie, if you could go to the next slide. I think there are 2 things you can do. One thing is get your house in order, practically speaking, right? If you're using a tool like TrustArc, one mitigating strategy here is actually making sure that things work correctly. Because as I mentioned with my mode analogy, it's a handshake. And this isn't just a TrustArc point. If you're using one of our competitors, which we hope you only use TrustArc, but if you are, right, it's still a handshake where that platform is interfacing with your house, for lack of a better word, your castle and your moat. So making sure that your website and your tag management solution are working correctly, knowing what pixels and tags, et cetera, you have, which again, we can help you with, but you need to know anyways. And making sure that all works correctly is one critical component of this. Another is really just strategy, right? Is the juice worth the squeeze in terms of what you're tracking and how and why? Broadly speaking, using a tracking pixel, isn't across the board illegal, right? To answer that one question, it's going to depend on if you're an opt-in or opt-out jurisdiction, what you're doing, et cetera. And also, it depends on if you agree with some of the plaintiff's counsel allegations versus what things like CCPA say. But Scott, I'd love to hear your thoughts on that.
I mean, I agree with everything you said, but the one thing you do need to keep in mind is you cannot outsource your own responsibility for the data you're collecting, using, transmitting, storing, whatever it is, right? So you need to actually take ownership both on your website properties, your applications, but also just in your own data collection, data governance programs, right? So we're in a world right now where there's a lot of attention on websites, but we're also collecting data through other kind of analog means too, and we have the ability to combine all that. So that's one. That's kind of your keep your house in order, and then effectively utilizing tools on your website. So, true story. I was on the phone with one of the leading plaintiffs' counsel in the SIPA cases last week. I was like, you guys keep changing your mind about why everybody's violating SIPA. What do you want us to do? And the guy says, you should go buy TrustArc. And that's both a plug for TrustArc, but it's also a plug for using technologies that give you a window into what you're doing, and then using a construct that allows you to look into the world of what you're doing with data. And then the final thing I would say, a plug for lawyers, is get a lawyer who knows what they're talking about in the space and can advise you. It's not the most expensive thing in the world, and the advice is pretty easy.
Awesome. But yeah, thanks everybody. Have a good day.